Let's see, is it working? Testing. 1, 2, 3. It's working. Excellent. Okay. Or it's break during the break, so it's a break. Decide I got to turn it on. I mean, this guy. I mean, to me, just doesn't look good as far as their credibility looks terrible. That's just my opinion, but a lot of people agree with me. Game over. Funny. Hey, we don't know, but it's fun watching these trials. And you have to question everything. That's just what I'm trying to tell people. You have to question everything. Don't believe one word they say. Imagine this is you. They can drum up. They can drum up charges against anybody. Trust me. So it's terrible. It's not good. Um, and then when they try to put on their case, look how bad it looks. They look totally inept. Terrible. Inept. The words there's I don't know, possibly, maybe. We can't be using those words. So I don't know. Anyway, it's interesting. Who doesn't like a good trial? What? There's no better TV really than, and it's just fun to watch, and we can all be a lawyer. It's great. It's fun. Who watched the OJ trial? Remember the OJ trial? What was another one? The Jean Bonnet Ramsey. Let's see what else. Oh, the girl who killed the baby. She was just in the news. The baby was in the woods. What was her name? Oh shoot, was local. Remember her? Casey. Casey. So, who doesn't like a good trial? And this was supposedly just a short break, so they should be back soon. In the meantime, let's do the pop out chat. Here we go. Pop out the chat. Do you do pop out chat? That way you can move it. I'll move it over here. Get it out of the way. Open up the screen. Then you got to do it again. Close that. There you go. Volume's up. That's all we can do. But it's fun to watch. And the other thing is I like recording it. And this way it's recorded on YouTube, Rumble, and my X. So kind of a good way to document history too. And if you ever want to go back and do clips, I can do that and stuff like that. So it's not a bad idea to document it and record it. Hey, and even if 1, 2, 3, 4 more people watch it that weren't watching it before, that's good. Good thing. So go to X and retweet it. Go to Rumble and share it. Go to YouTube. Follow us on YouTube. We need some YouTube followers. We were over 1,000. Now we're like under 1,000. So go to YouTube. Follow us on YouTube. Help us get back to 1,000 on YouTube and over 1,000. What else? Make sure you're following on all those platforms. Share them out. Put them in the email. Send it to Grandma in the email. So I don't know. It's been good. I've liked it. This has been fun. I've been. It's hard to not watch it. To me, it's good. It's fun because I don't believe them. So for me, it's fun because I don't believe one word the government's telling me. We'll see you in Valhalla. And then they lost me at 30:06. I don't know. It's not really. If anybody knows about a 30:06, You shoot somebody in the neck with a 30-06, it's a big deal. It's a big deal. You're on the verge of taking their head off. Oh, it won't blow his head off. Okay, it'll blow his neck off. It's going to go right through. The whole back screen will be filled with blood splatter. Where's the blood splatter analysis, right? And you saw how the wound came. It was like, poosh, go, like that, right? That is not a typical gunshot wound. It really isn't. It's just not how it works. You're going to have an entry and you're going to have an exit. And the exit's where you're going to see the bigger hole. The entry is the smaller hole. And the exit's where all the, blood splatter, especially with a 30-06. You have a lot of blood splatter. There's no blood splatter analysis in this whole thing, you guys. That's a huge tell. That's huge. Where's the blood splatter analysis? And even if it was just this shot that they're calling a shot, you should still have a blood splatter.
My dad never looked back at his old jeans after I gifted him these.
That's the one problem with this AP stream and just about any stream is you've got to head off the ads, or you have to let them just play through, which sucks. They're not that long, but that means you have to sit here and monitor the stream, which I really don't want to do right now. So I might just let the stream go and have to let the ads play, and that's just the way it goes. I'm not sure. For a minute, though, I can monitor it. So in the meantime, I don't have any pages up. Here we go. Where's this one? There it is.
Session. We left off with Agent Hull was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. there are sub-issues. There's also a problem under 1102, because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, or that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. what Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here, in this proceeding, what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met. The book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt. and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve, with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the targeting enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly and one of which I think is appropriately discussed at sidebar because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Englehart's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court or
whoever invented this deserves a raise. I can't believe it's already 2025 and people are still using those old, disgusting sink plugs. Come on, those things should have been in the trash years ago. It's time to upgrade. And this little gadget completely changes the game. Just press down and done. Installs with no tools, no plumber, no stress. You can use it to drain, seal, or open whenever you want. If something falls into the sink, hair, a necklace, a ring, no problem. Just open it and grab it. It saves your stuff and catches every single strand of hair. So no more clogged drains, no more disgusting mess, no more chemical cleaners. And the best part, it's on sale right now. Once it's gone, it's gone. So grab yours while you still can.
When it comes to what's in your bag, size matters. The Original Bag. Choose from full-size favorites starting at just $5.99, only at Hardee's. Because hard work deserves more than a teeny bag and an empty wallet.
That this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has 2 roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, one doesn't, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say, constrain you from saying, well, I don't know what you're going to say, but
Yeah.
I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, you know, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly Twilight Zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment. It's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I looked.
The Jimenez family are having battery issues, but an AutoZoner helps them find the right Duralast battery.
Celebrate free at AutoZone. Free products with exclusive deals now through July 27th.
Get in the zone, AutoZone.
So fast.
So easy.
So local.
So fast.
So easy.
So local.
So fast. So easy.
So local.
So fast. So
easy.
That's what I was gonna say.
So fast. So
Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds. But at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here. And, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement
with Mr. Kirk's political expression. None of that appears in this document. There may be other evidence of that we'll have to see. But there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think that the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
Okay. All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to bring, I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point when it becomes relevant based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed.
Need parts fast? Need them now? We're O'Reilly Fast. Just one part that makes
40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right.
front, cover up. I mean, it's such a disappointment, but I figured out he's always been bad. He's a chameleon. Sorry, go ahead.
No, you're fine. And yeah, and to your point, when he has come out since being in the FBI and done a complete reversal on all of these things that he helped build his audience and build his fortune by pushing these narratives when he was on his podcast, it's not just that he's doing a complete 180, but he's talking to everybody like they're stupid now for ever believing these things in the first place. I mean, it's like the gaslighting and the total propaganda, and then calling all of us, doomers and panicans, and that we're all bad guys for asking these questions. Like, dude, we're asking questions about stuff you were talking about for years, and you haven't sufficiently explained to anybody why you've changed your mind about any of this stuff. You've done a complete reversal.
Same thing on Kash Patel. What a disappointment. But you never 100%. Liked him. I tried to like him. I mean, this guy is incredible. What do you think's going on with that guy?
I don't know. I mean, look, when I look at both of them, I see two people who I think wanted to go into the FBI and wear cool badges and wear cool uniforms and fly around on private jets and live like playboys and live, people ask all the time, well, do you think that the deep state was exposed to them? Do you think they saw behind the curtain and they were scared straight? And so they did. In my opinion, that gives them too much credit. I actually I don't think they were ever serious in the first place. I think they wanted the attention and the eventual fortune that would come from being somebody who worked in the FBI under this administration, thinking that everybody was going to see them as some sort of national hero. And I don't think they had any intention of actually doing any of the things that they ever said they were going to do.
And that's my next point for you. You're astute on this. I want to get your take. And I had Mark Mitchell on, and the White House heard it. The vice president did, and flew him up there from the show. And he met with him 3 hours, an hour with Trump, total 3 with Vance, Wiles, and others. And to her credit, he was like, oh, no, he needs to listen. We need to stop this. And Mitchell was saying, no more billionaires, no more, all this stuff. People want to hear about jobs. They want to hear about all this stuff. All this stuff's hurting you over here. And Trump really didn't listen, but now his poll numbers are like 30 from 58. We're going to lose the midterms. Now I know internally Trump is upset, but he can't seem to change course enough. He has criticized Netanyahu some. So it's so sad to watch Bongino and Patel destroy themselves like deer in the headlights and do all this and now be so unpopular and then pretend that attacking us is somehow meaning they're the winners when you've seen Levin, Shapiro go from big audiences to almost none. I mean, Shapiro's gone from millions of views per YouTube to like 5,000. Levin is in the toilet. They're all destroying themselves, and we needed them to be good and help save the country, and they seem to be digging in. What do you make of this?
I don't know. I really think that this all backfired, and I say this all the time. No matter how I feel about how things are going right now, one thing I'll always say is that I will always thank President Trump for being the person who got me to see that there is such a thing as fake news and propaganda. I would not have walked away from the Democratic Party if Trump hadn't run for office. But the problem with that is that Trump sort of woke everybody up. And Trump got everyone to see things are not what they think they are with our government. They're not what we think they are with the media. But then it's almost like they forgot that they woke us up. And now they feel like they can just kind of keep repeating these talking points to us that are obviously not true. And we know what they're doing. And we know that what they're saying to us isn't real, isn't true. You know, when you're telling us like, oh, the economy's never been better and the people have never been thriving and business, people are not feeling that and they're not seeing it. And they know exactly what you're doing. I love your point about the billionaires. I think that's been one of the biggest betrayals. Watching Mark Zuckerberg and Peter Thiel and all of these people that were at one time enemies to the administration, and every Trump voter. I mean, these are the people that mass deplatformed Trump supporters, caused 10 times more damage to the January 6th defendants than they already would have been going through otherwise. And now they're pulled into the fray. I did one of my videos yesterday, like you were just talking about. Like, look, I'm not trying to just be a negative Nancy. I love how you always say you call balls and strikes. I'm trying to call balls and strikes too. I'm trying to give praise where praise is due. But President Trump came out yesterday and said he's working.
This hearing?
Oh man, that's a really good question. I had to get into the courtroom and really see what's going on there. I think you've probably reported on the fact that Erica Kirk and her and Charlie's parents were 100% sitting next to each other, despite everything that Candace and her fans have been saying. They've been in solidarity together. One thing that is important to note, this is kind of fascinating actually, and maybe this hasn't been talked about, is that there were two ways to get into the courthouse. There's the one off of, and I'm totally going to mess up the street, and I'm just thinking offhand, I think it's 500, where now I feel like I'm off. I literally lived in Provo and grew up there, and I can't even remember which street was in front of the courthouse. But in any case, there's a main street right in front of the courthouse, and then there's the back way, and that's where all the media is. And so you have a decision to make if you are entering the courthouse that day of which side you want to go into, and you can do either of them. And so there's a reason why people either snuck through the front, which would be Don Jr., for example, would have snuck through the front, or maybe underneath. I think probably underneath, since no one even has a picture of him going in. I don't think, not that I've seen. Or you can do what Erica Kirk did, and we got a tiny video of her, and she was rushing in through the front. Now, the front is not where the media is. There's not tons of reporters there. There was only one person there. The back is where the media is. And so anyone who walked through that side wanted to be seen by the media. And this is what a lot of people are missing. Like, I had some criticism on my ex of, why did you film Charlie's parents? It's like Charlie's parents walked through the media in solidarity with Erica and Charlie. The whole reason they walked through was to show people we're here, we're strong, we're not afraid of Tyler Robinson or his defense team. And that was true for Brandon Tatum as well as Graham Allen. The defense attorneys did it to try to show strength as well for Tyler Robinson. Erica Kirk, on the other hand, had a very different strategy. She didn't want the publicity. She's had plenty of that. She wanted to sneak in, not make it about herself, and that's what she's done. So that was kind of an interesting thing that I observed yesterday.
That's some interesting insight, to say the least. This is the first time that I'm aware of that we're seeing Charlie's parents at all. So yeah. I am glad to see that she's there. I'm glad to see that Erica Kirk is there. I don't know, man. That's where you start thinking about it, and you start getting sad, right? That is the depressing part of this, and realizing, having the empathy and sympathy that most human beings normally come just readily equipped with, that so many of the Candace folks apparently don't have. That's where things get real, and it's interesting to see how all of this plays out, but when it goes to them, that's where the human component is, and most of us, it definitely becomes much more depressing.
What about
do you know if Elizabeth Lane was there or in court or anything else?
I looked around for her. I didn't see her. I think the odds of her getting into the courthouse without someone seeing her are pretty low. The only way she would be able to get in is if she got a place with Tyler Robinson, and I don't think that would be possible. There's no reason why their defense would want someone like that in the court. I don't think there's any way she got into the courthouse. I mean, I'm 90% sure it didn't happen. I have people there on the ground. I have people I know who were there yesterday inside the courthouse, inside the room. I have people there today, 3 of them, who I spoke to yesterday, who are in the courtrooms today. and they have not seen Elizabeth Lane. They're people who would recognize her if they saw her. And like I said, I was around the courthouse. I would have recognized her if I had seen her. There's not a lot of places to hide. It's just like right there. It's very open. I was looking. I was there for several hours. Didn't see anything.
Yeah, on all the wide shots over on the Tyler Robinson side I've been looking for, I didn't see her there. I know there was a lot of talk. She tweeted multiple times that she was going to be there, and she's even suggested that she was going to confront Erica Kirk, and hopefully they're keeping her away.
Yeah, she won't even have an opportunity. I mean, all of that is just total talk. Like when they were moving, I watched her bodyguards move her in. There's 2 bodyguards. No one knows who's in there. There's black Suburbans everywhere, and you've got random people coming out all the time. Sometimes it's a prosecutor, sometimes it's a media personality, all kinds of famous people coming in, and randomly a black Suburban pulls up, 2 bodyguards step out, and in a matter of 8 seconds from the door of the car into the courthouse, and you're done. Nobody is allowed in the courthouse at all unless you have a hearing or you're those 14 members of the public who are allowed in, who waited in line. Even then, you're with a bailiff the entire time. There's like physically no way anyone like Candace Owens or Elizabeth Lane are going to be able to confront Erica Kirk.
That's good to know. That's good to know. Did you get a chance to speak with Graham Allen or anybody else that was attending?
I tried to. Brandon Tatum and side, but I was on the media side, and there's
all right, so let's go to video file. Let me pull that down. Add this. And okay, this is the
Okay, so now tell me where you see a rifle in that jacket. Look at it open up and fall down like to the ledge as he's about to grab the ledge and jump off. There's no rifle in that jacket. That appears to be a jacket to me. I mean, you can see it open up and then close, but there is no rifle in that jacket, stuffed in his pants. How would he have bent down and kneeled like that and then jumped off of a roof with a rifle in his pants? That video right there completely destroys the Fed slop narrative that there was a rifle in his jacket. Bullshit.
I agree. It's very, very clearly evident that that's just a jacket. That's all it is. It's just a jacket.
I think you're muted.
There's
bro.
no rifle there. No, I'm not muted. It must be on your end. Yeah, there's nothing. It's clearly it's just a jacket. It might be a towel, but it's just a jacket. It definitely isn't a rifle. He said there was a long black object or whatever. No. There is no long black object here. That's clearly, it's floppy. Guns don't flop. That's the other thing is when he jumped down, that's floppy. Whatever that is, it's floppy. Guns don't flop around like that.
Take me to.
Hold on, Mitch. Hold on, Mitch. This is a valid conversation.
It's evidence.
Okay, walk me,
Man,
walk,
if I'm
walk
a
me through
juror,
that though,
dude.
Eddie. So you said this car is there, and then what's the next thing, Eddie, after the car?
You're gonna have to repeat that, man. It's bad.
I'm sorry
reverbing
about
here.
that. So I was asking, you said that his car, so you're saying his car was on premise at that time, is that right? Okay, now
Yes.
what's the next piece of evidence that kind of does it for you?
Well, they're following his footsteps, right? Or this individual that I'm 80% there that it's Tyler, right? I can't get a super clear picture. So they're following this individual, leaving, coming back, parking his car off campus, having this weird walk like he's got a gun in his damn pants. They're tracking him all the way through. Now, what I'm saying is tomorrow we're going to get to more physical evidence, such as DNA, things like that. And then I don't know how you are going to spin that, but it's looking
So you
very
mean
bad.
DNA on the gun?
Eddie, it doesn't matter. It doesn't matter what we perceive the video. The expert testifier is the evidence, and that
No.
expert testifier said that is an expert
That's not true.
have identified in that
He's not an
video
expert seer. Do you
Tyler
understand? That's
Robinson.
not what expertise is. That's incorrect. Everybody
Yes,
sees
he
the
is
same.
a
He's not like,
police
I have
officer.
Okay, the
special
very
eyes.
expertise that you guys are.
David do
Wait a
this
minute, Eddie. Wait,
nonstop?
wait,
For
wait,
God's
wait.
sakes.
The very expertise that you guys are saying is an expert. Okay, couldn't remember that if the gun was a 30-06. Okay, couldn't remember
Right.
that. Couldn't
Right.
remember. By the way, this gun that they keep talking about and
The
these
pistol,
bullet
the pistol
fragments
holster, the pistol,
and
the
these
pistol holster.
these bullet fragments and all this reference to ballistics, okay, never gets all these little pieces never seem to be able to be put together. They don't have.
But we haven't
Yeah,
gotten to the
but you
bullet
know,
No, I
Miss,
I know, but
yeah,
I'm they.
and
That's
Miss
not
Lou,
He
I
even on the
want
doesn't
to.
even
record.
remember. David, he doesn't even
Sorry.
remember that it was the 30-06, and this is one of the key investigators.
Yeah, and Miss Lou,
So
But he has
my
done
point to
the
you, Miss Lou.
significant.
No,
But
hold on one
David, you
second.
don't have to
My
just
point to
speak
you, Miss
anytime.
Lou.
Can we
You
mute
just
Mitch
need
for
to
just 3 seconds so we can
I
have a
am
back and
resp-
forth
I
conversation?
am
I
responding to
literally
Miss
every time I
Lou.
talk, he just
Just
mumbles along
right.
over
I'm
talking me.
responding,
can
Miss
I
Just
Lou.
hear
allow me.
David,
Just
please?
No, he's
right.
not
You're
Can
responding
I
yes. I
hear
every
respond.
time.
For the record, I just want to throw this out there. AJ has looked it up. It does look like the prosecutor is Mormon. So good job, AJ, or at least very religious. More on that later.
Okay, I'd like to hear what
Okay, just to
David
get
has.
back, just 1 second. But I was in the middle of speaking, so do you mind, Miss Lou? Because I've
No,
never talked
I'm
nonstop.
responding
I'm
to
not even
Miss Lou.
having
Okay,
difficulty.
I'm doing this
You're
for free.
not.
You're
No,
getting
Can we
you
please
literally
$7,000.
were
mute Mitch
interrupting
and
Okay,
put
me
him
while
in
I was talking
timeout?
before, and then
right. So
distracting
Miss Lou.
you.
Miss
No,
Lou,
I
Miss
don't
Lou,
understand. I was in the middle of
you
speaking
just
to
lost
him.
$7,000.
Yeah, right. So I
Great, but I was in the
I
middle of
am
speaking,
responding to
and then
Miss
he
Lou.
overtalks me,
Listen,
and then I
sir.
Mitch,
distract the conversation
Mitch,
over
will you
here.
stop with the misogyny? Why are you talking over all these women all the
Yeah,
time?
What
yeah.
misogyny? David
I'm
is not a
asking
woman.
Miss
You're
What are you
Lou
talking
talking
about.
about?
questions.
Miss Lou is
It's his
asking
Jewish schizophrenia and supremacy.
Right, I know.
No,
It's just
I
disavow,
understand,
disavow,
but this
right.
whole
disavow.
thing starts because David
So
has to
my
David,
overtalk
David
every
was
time I
asked to.
speak.
David and
I
Miss
was talking
Lou.
right,
calmly.
David and Miss Lou are having a back and
and
forth.
it's a
Let them
simple
have their
question
back
too,
and
I
by the
ruined
way.
forth.
every space. It
Right,
doesn't matter if
and
we're talking
unlike
about
you,
ping
it's not like
pong
a
Can we put him
long-term
in
everything
thing.
timeout
else.
for 5 minutes,
Mitch,
please?
Yeah.
please don't make me drop you.
Anybody could have been walking up the staircase. That is such a grainy damn video that you can't make out real good detail. I mean, you would think with the technology these days, that would have been a lot better of a picture, but it's not. So, and again, whatever type of rifle gun you have in your pants, how are you going to bend your knee? I wouldn't be able to bend my knee if I had a rifle going down my leg to go up the stairs. That makes no sense either.
Well,
And
I
again,
appreciate your
you
time
know,
and your
perspective on this, and I see your position that you feel Tyler Robinson is innocent and he's a patsy, framed.
Yep. And thank you for covering this very much, JLR.
Thank you
I
for
love
your time.
following you.
Thank you. You have a good day.
You too.
From New Hampshire. We like to hear different people's perspectives. We got Shannon and we got Rich. Jill, I don't know what's happening with your device, Jill. But if you want to come back, I'll get you in. Hi, Shannon.
Hi, JLR. How are you?
I'm great. How are you?
Hot. It is hot in Oklahoma.
Oklahoma. Oh, yeah. The center heartland of America. Yes, it gets hot.
Yeah.
It's like
Yeah.
100.
You came through our town when you were doing your storm chasing. I live
What
in
town?
Guthrie.
Where at? Guthrie?
Yep, Guthrie.
Yeah, Guthrie, Oklahoma. Remember that, covering the Guthrie case and then going out there and like, hey, Guthrie. Oklahoma.
It's a very historic little town.
Yeah.
Well, I just wanted to say that what a mess this court hearing has turned into. The defense just, I expected it out of them to just keep trying to, put things off, and try to demean the state by objecting on everything. I expected it, and I'm so thankful that Tony Graff is standing up for the state. I really am. Charlie Kirk was a good man. I don't care what anybody says. He was a good man, and he meant well, and he did a lot of good things for a lot of people. And it's not really that I followed him. I didn't. My son did, because my son is in that age group. But I knew of Charlie Kirk through my son, and I knew the good things that he was trying to accomplish. And to make this political and religious, I'm not sure how I feel about that. I think that politics and religion should be left out of it. You're either guilty or you're not. And he admitted 5 separate times that he shot and killed Charlie because he had the opportunity. So that's my opinion.
Yeah. I appreciate the opinion perspective. So you think Tyler Robinson is guilty and did this crime?
Oh, yeah. And I don't think he worked alone either. I think
Okay,
he
so
had
you're
people cheering him on.
Do you think co-defendants, co-conspirators? Do you think like plotting and planning, or just cheerleaders?
Maybe a little bit of both. Cheerleaders and co-conspirators. I still don't understand why and how Twig is getting by like he is. I'm like, why are you protecting him so much? He needs to have his butt in court.
I think he's going to make an appearance.
I hope so.
This at one point, his testimony.
I
mean,
hope
there's a
so.
lot of things that have not been discussed yet. The DNA, the texts, the note.
Yep.
Twigs, there's still a lot of, and other agents coming up. 2 agents we're going to hear from, Falima and Davis. I mean, there's still a lot of more evidence that the prosecution is going to present here.
Yeah, and I'm anxious to hear it. I really am. And poor Nancy Guthrie, oh my goodness. That's another hot mess.
I know. I'm gonna probably do an Guthrie live tonight.
Oh my goodness. Well, I'll be there watching. Me and my husband, we have been following you, not as long as a lot of people, but since the little boy come up dead there in California.
Daniel Harrow.
Yeah, them. Oh my
man.
God. Oh my God, that was horrific. I was like, oh, devastated over that. But no, we follow you religiously. We love it. We love you.
Thank you. You take care, Shannon.
You too, hun. Take care.
Bye-bye.
If you're watching on the internet or listening on the radio, 512-42. All right. What are we going to intersperse with your calls? Bombshell developments like this happen, and it gets almost no attention. A high-level federal judge has ruled that they're going to forcibly inject Amish children in Pennsylvania, Illinois, you name it. Democrats are passing laws and trying to pass laws to get rid of informed consent, to get rid of basically the Nuremberg Code and the Geneva Convention. And we have laws that fit to that. There are no laws that can make it take shots, but they then behave and act like it's illegal and send CPS after you or deny you access to doctors, all this stuff. And remember, they told you the COVID shot will protect you. You can't spread it. You can't get it. All lies. It erases your immune system, gives you all these issues. Even Bill Maher's woken up now. Or really, he just knows his audience has. He's a chameleon. Or maybe he's, half has some soul. I don't know. He did say, don't censor Alex Jones. Even he gets to speak. But he's come out. So here it is. Federal court rules against Amish families in religious exemption case. Will Supreme Court have the last word? Well, they better. I'm going to read that in a minute and then get to Bill Maher. But that dovetails with this report I've got right here. And again, what frustrates me to no end, these all tie together, is when I see these videos almost every day in New Jersey, in Illinois, in California, in Washington State, in Oregon, and it's 14 states have gotten rid. Oh, Connecticut's doing it right now, too, so it'll be 15. Well, they just passed that, actually. Guys, look, I can't remember, it's 2 weeks ago. I think Connecticut just got rid of religious exemption. So it's a regulation. It's not a law, but, you got to take it. And they buffalo people. I've seen cases like in Maryland. It's happened every few years. Crying black people, mainly, because they kick you out of school if you haven't given your kids the shots. It's like 68 of them now. And there's not a law to take the shots, but when they say you violated the policy, now your kid's truant. Now they arrest the kid and arrest the mom. And it just so happened in the videos I've seen in the local newscasts we've read over the years, it'll be crying black people with police dogs outside the courthouse, like about a concentration camp, about abusing black people. And they're crying saying, my younger boy got sick from it. I don't want to do it, but I'm going to jail and he's going. And they're in the courthouse shooting him up. Oh, I ought to dig those back out. I haven't seen one of those in about 2 years. I've been on there 30-something years. I've seen in Maryland probably 8 or 9 times that comes around. We're tired of these people not giving their kids their shots. They don't care. And then it happens to be the black neighborhoods they target. But they're targeting others as well, as on the newscast is crying. I mean, literally police dog. I mean, I'll ride over that all day long. So that's when you're supposed to riot. I'm not calling for, seriously. So this is all over the world. They're pulling similar crap to this. But it dovetails with these reports I see, and it's always a mom. And then they don't have the background. They don't know what's happening. They're like, my 13-year-old or my 12-year-old, because the law is all the same, including in Australia and New Zealand. It's the same laws program. At 12, they're going to move it down lower. You can't buy liquor. You can't buy cigarettes. You can't join the military. But the government's saying you have control over your medical future when you're 12. And then the government comes in and the schools and systems of brainwashes for transgender fast tracking, sterilization, chemicals, prescription sterilization. That's what it is. Surgical sterilization. But more than that, you see it in Canada and the UK and the Netherlands is the vanguard. They come in and tell kids, oh, you're depressed. The state's now your ward, or you can sign up to be killed. And they're now killing kids age 12 in Canada, in the Netherlands, and in the UK. They killed 100 and something thousand people the last 2 years in the Canada alone. And 99% are liberals and white. Don't believe me, just type in 99% of those, 99% of the 100,000 euthanized in Canada, assisted suicide in Canada, were white/liberal. And then it's, oh, you're depressed, you're 12, you have the your parents don't have the rights, you have the rights over that. Medical rights are consented ages 12 and 18. Yep, see, there it is in the news. It's bioethicists, it's administrative law, and they're just doing it. So see, here's this mom like, God, what's this? My kid goes to the doctor, my kid goes to the hospital, and I'm not allowed to get on the portal? Everything's through a portal now at the pediatrician or your doctor or whatever. And now the portals are AI. And I call up my doctor's office, I don't go to the doctor a couple times a year, and I'm like, oh, I'm coming down there. I'm not talking to a robot. And even, smaller clinics and chains are doing it now. It's removing humanity. And like, oh, you understand the magnitude of we're going to forcibly inject the Amish. That means everybody else, folks. By the way, the Amish live on average to 86. The average American lives to 72 now. Oh, we've lost a few years. Just a decade ago, it was like 78. We don't live as long. They're killing us. We're dumbed down. Our IQs are dropping no matter what color you are. This is insane. And so look at this. A federal court last week ruled against a group of Amish parents who sought religious exemptions from school vaccination requirements for their children, a ruling that legal experts suggest may lead to U.S. Supreme Court shutdown that could determine the future of religious exemptions. And they're claiming jurisdiction over the Amish schools and saying you're under our school board control for schools. Since when do private schools have to do that? In its ruling, Miller versus McDonald and the U.S. Circuit Court of Appeals New York state law eliminating religious exemptions from school vaccination requirements is neutral and generally applicable, doesn't discriminate against specific religious practices, and furthers the state's interest in protecting the public from disease. Yeah, Governor Hochul. Forced injections, and this will affect the whole country. I mean, this is war, folks. They're coming with something that hurts you, that they know doesn't protect you. 68 shots. In the 1960s, we had 1 in 50,000 with autism. Now it's 1 in 33. And that isn't over-diagnosing. I've been around 50-something years. I go to the mall, a movie theater with my kids. Half the kids look like zombies. I can't go to a restaurant or anywhere without kids going, blah, 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 blah. They're autistic. They're fried. You see it? We're the fattest, the most unhealthy, the diabetes. Now 20-year-olds are getting Alzheimer's. They're murdering us. 30-something million in insurance actuaries killed by the shots. And now, 14 states. Is it 15? And it's pretty similar. It's 14 or 15 states have passed laws. You pull this up from memory. Have passed laws to get rid of religious exemptions, and a similar number have done it to take parental rights away, and at 12, the kid has all the rights, and then the state can brainwash him. And the school program that secretly fast-tracks them into transgender with the club, and then they keep a secret file and give them a secret social worker and a secret lawyer and tell them your parents are going to persecute you, and they spy on the parents' background to see if they're going to be part of it, and then try to bring the parents in. If the parents don't like it, they take the kid, put them in trans foster care. I mean, this is outrageous. Look how far they've taken us. And sure, Trump, get men out of girls' sports. Okay, they've done some pushback. But everybody's focusing on men and women's sports. That's bad. That ain't nothing compared to brainwashing and taking your kid away. Oregon, Washington State have all passed laws. It's like 7 or 8 states now. Pritzker's been trying to pass it. I don't think they got it through yet. That if your 7-year-old comes home and says, I'm really a girl when they're a boy, or vice versa, and you say no, and they send social workers out and you fight it, they take your child and put them in a trans facility, obviously where they're getting molested, and fast track them into the cult. So, and a lot of states have already basically gotten rid of it, but now they're officially getting rid of all these protections. They are saying your kids belong to us. Again, they can't sign a contract, can't get a loan, can't get a mortgage, can't join the military, because they're not of the age of consent, because you can trick a child. So I'm mighty pissed about this, folks. And this is a big, big deal. And the reason I say it's probably worse than I'm saying is I'm going from memory. It's always more. I remember saying like a month ago, 24 states have passed laws that if you criticize Israel in any way, you can't get a state contract, and it's a felony if you do take the contract. Texas has that as a law. And the crew searched it. It's 38 states now. So when I say 15, 14, I guarantee it's worse. In fact, where I'm wrong, 90% of the time when I'm wrong, it's that I underestimate or I give you old numbers. People hear this stuff, they go, this can't be true, it's not that bad. Folks, it's almost always worse than I'm telling you, okay? I had a big vaccine expert on a few months ago, and I go, yeah, it's like 1 in 50 kids has autism. They go, no, the new number is 1 in 33. And I looked it up, and it's like, what the hell is going on here? So let's go ahead and play Bill Maher saying, hey, even if you have natural immunity and already had COVID, and that's the 100% gold standard, why do they push it on you when it can kill you when you already have immunity to take the same shot? Oh, yeah. But it didn't give you protection anyways. It's all a lie. He's like, well, they just want to force it in my body. Yeah. To grow a graphene oxide matrix in you that can be scanned by wireless, and it attacks your testicles and ovaries, and your heart, and your brain, and your cardiovascular system, and your liver, and they knew it all and suppressed it. It's on purpose. Bill Gates openly says he wants to reduce the world population by 80%, but he sure wants you to take a shot because he doesn't want you to die. I mean, come on, that ain't even 2 + 2 = 4, folks. That's 1 + 1 = 2. Go ahead and play Bill Maher and then dovetail it with a mother in Oregon told she can no longer have access to her child's patient portal. They're 13. It starts at 12. They're taking your children away from you. Play Bill Maher and then play her.
Why did everybody have to get a COVID shot? Even people with natural immunity. Natural immunity,
Yes.
which we always used to respect. But in COVID, no. Just get our product in you. And I'm not an anti-vaxxer. I'm just somebody who wants to decide which ones I want.
Yeah, if they had never, I remember the buildup to that, it's coming, it's coming, it's coming. And I think if they had just left it, here it is, this vaccine, it's available to anybody who wants it, I think probably more people would have taken it. But when you tell Americans you must, that's a problem.
But even more that bugs me is the natural immunity thing. I mean, for the people who are like, we're the science people. Well, there was nothing that was more settled science than natural immunity is the best. So if somebody has natural immunity, if they got this, I know a lot of people who got it like they were like, oh, you know what? I got sick in like November of 2019. I bet that was COVID. Yeah, I bet it was. I bet it was. And you could test it, okay?
Yeah.
Then I go, okay, now the fix is in. Now you're telegraphing that you just want to get your product in me as much as you can. And you know what? There are things that could come along. There's this hantavirus now where I want your product in me. But I want to decide.
You want to decide.
I want to decide when I want your product in me. I say that about sex toys also.
Oh,
I want to decide.
I just got done taking my son to the doctor, and they tried telling me at the front desk that I don't have access to his patient portal anymore because he just turned 13. Are you kidding me? He is under the age of 18. He is my child. I should have access to what his medical stuff is. That is insane to me.
So the reason that this mother is locked out of her own kids' medical records is because of Democrats. Democrats passed what's called minor consent laws, and they kick in at age 13 in Oregon. So at age 13, minors gain the right to confidential care in certain areas without parental knowledge or consent. So here are those ages. At age 14, you can consent to mental health, drug, alcohol treatment. At age 15, you can consent to general medical, hospital, dental, or even surgical care. Think of that. At age 15, you can get surgical care without your parental consent. And at any age, you get full confidential reproductive health care, birth control, HIV, STI, and you get treatments for all these things. And this is all without your parent knowing. Here's what's really wild. These massive systems like MyChart and Epic, they actually default to kicking parents out at age 13 from their own kids' care. Just wrap your head around that. Who needs enemies when you have the Democrat Party?
And it's actually 12 in all the other states. Now, I'm going to go to your phone calls in a moment. I got a bunch of other news, but I want to get a bunch of calls in. Bill, Bart, John, David, Rob, No Lock, and others. But before I do that, I am beyond excited about this. This new shower filter system is beautiful. It's got the healthy straight frog seal of approval, literally with a little froggy on it. It's beautiful chrome. It screws right on in 5 seconds with no plumber into all of your shower systems. You just unscrew the old one and it doesn't have a filter in it and put this on. It's the highest level filter you can get at a price lower than systems that aren't even as good. It took Bigley a year and a half to get this done. We've got all the tests, published studies, third-party top scientific groups that test products. It is amazing, and it's fast flow. You owe it to yourself, your wife, your husband, your children, your neighbors. It's a great gift to get this, and it does 180 long showers until you get the replacement filters that we sell that cost $30. Now, obviously, it's at full capacity for 180 showers, okay, and cuts things out up to 99%. Our gravity fed does it to non-detectable, basically 100%. You can't legally say that, but they say non-detectable. This is fast flow, so it's just 99. I'm sorry. But it massively mitigates at 99%. The chlorine, the fluoride, just all the forever chemicals that are in the water table, that are in the municipal things, toilet to tap, many of the big cities recycle sewage water with all the drugs that get put in there, and it goes right through. That's all the studies. Our water is one of the biggest things affecting us. Don't bend your gender. Filter your water yourself, and you absorb it through your skin in the shower and the bath. You absorb it into your...
Two completely
No.
different things.
No.
Now, I mean,
Yeah.
there's still a lot of people that are sheep that aren't online, but generally, a lot of the people that are online now, They see how they're doing these psyops. Like we've lifted the veil. Like
Yeah.
we now see their influencer network, how the White House has their select influencers, you know, that every
Right.
time they want to run a story and push it, they go to these people, and all these people push the exact same psyop out, and we know what to
Yeah.
look for, we know who to look for, and we call it and expose it just like that now, you know.
Yeah. That's what I was talking to my veteran buddy about that. Like, you can see right through to the psyop now. Like, just like within hours, like that shooting that happened in Australia at that festival. I mean, within hours, we were breaking that story wide open. The guy who was an actor, who was an Israeli actor, who was at another event, and
Crisis actor. Yep.
crisis actors, right? These things are real. These people are real. These people have experiences in this context. That's why you see that one guy who gave a testimony from the Charlie Kirk incident. He was a crisis actor at another shooting, at another mass shooting. And it's just like, it's easier to see now because
Sandy
we have
Hook.
social. Yeah, there you go. Sandy Hook shooting. So we have social media now. So, something that they created is actually, people are using for good. Like, but it's just wild, bro. It's wild. It is all connected. The Epstein class, I would say, is at the pinnacle. Is at the pinnacle of everything. You see so many different aspects of our society connected to Epstein. Just like, listen, when those school photos that you guys get for your children when they're in kindergarten and first grade and second grade, well, go look into Leon Black. I actually broke this story. I had as soon as the Epstein files were released on this last one, when they released a little bit of what they have, I broke a story on Leon Black and his connection to the company that does our school photos as children, with him basically having a company that owned it. And they've been collecting data on us since we were children. That's what this company was. They basically collected data. So why would somebody connected to Epstein have a company that does school photos for children? And I started getting messages in my inbox from various mainstream news media outlets, and it's blown now. But I told them, I said, no, they asked if they could interview me because I broke the story, and I said I wasn't the original one who released that. Sorry, I didn't want nothing to do with it. But then to see all the schools across the country making a stink about it, that's what the fight is about. It's about bringing awareness, exposing the Epstein class, and bringing truth to people, whether they want to chew on it or they don't. It is what it is. At this point, if people can't see what is going on, and even to the point of us being lied to on this second run with Trump, I mean, you just choose to be sleeping in a slumber at this point. It's all intended to wake us up. Now, you want to double and triple down and trust the plan crap. All that Q stuff was an intelligence agency psyop.
Oh, big time. The other thing I put out today, and this is what we started talking about earlier, but I got distracted. When I said we were talking about the Charlie is still alive, the people that are pushing that Charlie's still alive or whatever.
Right.
Hold on, where's it at? Let me find it. There's actually, I uncovered some stuff which honestly, I'm not ready to say that. I'm definitely not. I haven't, I don't believe that. I haven't subscribed to that theory, but I will say that this is certain. This information that I uncovered, it's very interesting, and it supports that theory, and it should be investigated. Whether he's alive or not, it should be investigated.
I mean, I know that's a little thought in the back of everybody's mind.
Pretty interesting. Yeah, I mean, I want to believe it, but I have a hard time going there because there's just so much evidence, Hold on, where's it at? Why can't I find it? Let me refresh. What's
Man, we sure did get psyoped with Cash Patel, huh? We thought he was one of us.
I know, man. Okay, this is it. Yeah. Yeah, so I found there's a phone number that recently showed up last week on her People Finder, on Erica Kirk's People Finder, right? And this phone number is a New Zealand phone number. So Erica Kirk has a New Zealand phone number listed now on her People Finder, but it's not a new number. It just, it just showed up, but it's on the People Finder. It says the number
Did you say,
valid
hold
since
on, bro.
February 7th.
Did you say Foot Finder?
No, People Finder.
I'm just kidding, bro.
Yeah, no. Okay, yeah. Not Foot Finder. Nah. We're definitely, we're not doing any of that now. But yeah, no, People Finder. But it says that the number's been valid since February 7th, which was 7 months before Charlie was assassinated. So that tells me, if that number was valid before Charlie was assassinated and linked to Erica Kirk in New Zealand, which, by the way, for all of you not paying attention, Valhalla is in New Zealand. People that think,
if
Charlie
you want your
went
car to look
Valhalla,
brand
see
new,
you in
be sure to
Valhalla,
use this.
Like Behel said, New Zealand. So the fact that the number was valid, connected to her from February 7th, 2025, before Charlie was killed, means that it's not just like some troll or something that's trying to wrongly connect that number to her, because it was connected to her before any of us were even talking about Valhalla, before any of us knew anything about New Zealand at all.
Which is not a terrible ordeal. Well, I probably have my pocket knife. Oh. Yeah, exactly. Right.
in session, so I would assume we'll see most people the next 5 minutes. Like playing on fire. Yeah, I think that it's theoretically gavelled at that time, and I bet there almost was at least 5 minutes late. I wouldn't be caught. Getting closer. What's our corner? Got Big Tom Spencer together? What's that?
Yeah, that's what I wrote. I wrote the exact language they used. Consistent.
You have a little alert set?
Yeah, so every time I decide my next word, I just get a swipe by it. So that way I can learn to flow.
So when they say fun,
Get like an umbrella. Huh?
still thinking you mess up your camera? No. That's why these camcorders are like half the size they are. It's just okay. And this isn't that bad. I've done that. You also build a fire. I know where its limits are. Well, fires are always nice and cool. Oh, they oh, because of the wing. Well, and you're under the smoke. So it's like 20, 30 degrees. It's like one of the weird things about doing fires in the summer. You'll pull a break from the heat. Unless it's really hot in one very specific spot sometimes. Do you know the name of burger? Yeah. Yeah. He's fun to work with, but it's weird because there's so many fires. He does fire. Yeah, that's our like both of us are fire favorite. But just a little listen, it's like has a bunch of fire. Yeah, I like fire.
I'm the kind of G the little homies wanna be like, on my knees in the night, saying prayers in the street light. Been staying most of the night, living in the gangster's paradise. I'm the kind of G the little homies wanna be like, on my knees in the night, saying prayers in the street light. Been staying most of the night, living in the gangster's paradise. I'm the kind of G the little homies wanna be like, on my knees in the night, saying prayers in the street light. Been staying most of the I'm the kind of G the little homies wanna be like, on my knees in the night, saying prayers in the street light. Been staying most of the night. I'm a nigga with an attitude, thanks to y'all. And I don't give a fuck.
I've been rocking this chair for 4 years now. Viper chairs are the best. But then I was like, you know what? How is this chair gonna help me laying on the ground working on a car? So then I got this foam pad. And this foam pad's super rad, but then I'm like, yeah, but this thing needs wheels. So then I got the one with the wheels. And then I was like, yeah, but my buddies are watching me build cars and they need something to sit on. So then I was like, hey, here's this chair. And the top comes off and it holds stuff. But then I was like, yeah, I need a cart though that holds stuff too. So then I got the cart that holds the stuff. And then I was like, yeah, but my other friends need a taller chair. So then I got this taller chair. And then everybody's like, hey man, it's hot in here. So then we got the Viper fan. And then Viper was like, hey, do you want your own chair? And I was like, yeah. And then this is that chair.
Please be seated. Court is now in session, noting the presence of all counsel and all parties. All right, Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time. And we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in. All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team?
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt action?
It was a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items. Well, let me tie up that thread. The gun. What was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. I think that's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. Can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from
Yes.
the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burt? No. All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, TOW from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it is.
On September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
I'm going to object to that. It's cumulative. We have the analysts here who can describe what the report is. Not sure it assists the court to be having her read from a report that's already in evidence.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burt.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled B-A-K-K-E-R.
And Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority 1 level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your
Do you recognize this place? In your neighborhood at any given moment, at least one child needs a loving foster home. We can limit the adversity a child experiences by placing them in a foster home that is in the neighborhood they are familiar with. Will you consider opening your home to a child? We will help you do it. Together, we can make a difference in a child's life, make your community stronger, and you will experience one of the greatest feelings in the world. Go to wellpointcare.org/together to learn more.
Folger and Utah SBI SA Dave Hull gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in her report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
okay.
Correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one, one more down. I'm not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
Can you
sorry.
take that down?
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mm-hmm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4 fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
my data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at
during peak season, we get a lot more questions about what's available, what's not available, pricing, and
numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what it differs amongst us, with the exception of identical twins.
But with within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is drop-out?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%?
This 3D print has a whopping 38 colors, but the printer it was printed on only supports 4 filaments. It wasn't produced by an expensive color jet printer from the likes of Stratasys or a custom machine with a mixing nozzle. Nope, this was produced with a hobby-grade FDM printer. This one happens to be a tool changer. It's not a hardware innovation. It's accomplished in software space, specifically this software, a fork of SnapMaker Orca called Full Spectrum. I've been playing with this over the past couple days, and honestly, I have been blown away by the results. I genuinely think this is one of the coolest things to happen in the 3D printing industry in a long time.
20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Badoli, correct?
Correct, yes.
Who's Bruce Badoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory?
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant. And I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training looking at the data. That's something I input into StarMix.
All right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce?
I believe so, yes.
Federal agency?
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure. That the it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you?
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is, as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, the credibility determinations are not proper for the court to make here, for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that, and a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. So, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have, as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes. And could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as...
We're celebrating free this summer at AutoZone. Shop deals for a free STP oil filter, free Duralast brake pads, and more free deals. Now through July 27th.
Get in the zone, AutoZone.
You need parts? We got parts. Product availability. Just one part that makes O'Reilly stand apart.
Right now, get one free set of BrakeBest brake pads when you purchase 2 BrakeBest Select rotors. You can upgrade to BrakeBest Select brake pads for $10 more, or upgrade to BrakeBest Select Pro or Import Direct pads for just $20 more. Restrictions apply. See store for details.
O'Reilly Auto Parts.
Grounds.
All right. Did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right. So as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is relevant and that it is admitted into evidence. As regards to publication, what is the request, Mr. Byrd?
If I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure. I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. So the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log, entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those 2 reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have 1 reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. Mm-hmm. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on her discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So Baker.
And so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here, and once again, I think these are appropriate questions to raise in a 702 hearing. But with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropherogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropherogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon so I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in response to Mr. McBride's statement that he was unaware that this is going to be an issue. He and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right. Under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a
publish.
yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Council, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank
you, Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropherogram not through running it through STRmix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct.
My dad never looked back at his old jeans after I gifted him these.
Trust me, these will become your new favorite pants.
Designed by a 63-year-old apparel expert who understands exactly where men's pants pain point lie. Whether you're 50, 60, 70, or even 100, you always deserve the comfiest and most practical pants. Multi-Pants, best-selling comfort cargo pants for seniors in 2025. Non-stop stretch supports endless freedom to move. Lightweight woven fabric. Releases heat from aging skin. 6 pockets that are practical, sleek, and versatile. 10-inch elastic waistband. Indulge your adventure with this effortless, flexible cargo pants. 65% off. Get yours now.
Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a third person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twiggs should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So, for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly. But in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up StarMix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time to take a 15 minute? All right, let's take a 15-minute break. Let's see. We'll come back at 3:50. Court is in a brief recess.
All right, so here's the deal. National Concealed Carry Reciprocity is about to change everything.
It means if you have a permit, it could be valid in all 50 states. But here's the catch.
You need to already have your permit before this kicks in if you want to be grandfathered in.
I didn't wait around. I got mine online. No classes and no range time.
Just put in my zip code, answered a few easy questions, and did the whole thing from home.
Took like 10 minutes.
No reason.
2 weeks later, got my permit in the mail.
It's good for 5 years, and when it's time to renew, you just send in a renewal form. That's it.
It honestly couldn't be easier right now, but once this goes live, the system's going to be slammed. So if you've been putting it off, don't.
Lock in your permit now while you still can. Just click the link and get started.
So fast.
So easy.
So local.
So fast.
So easy.
So local.
So fast. So easy.
So local.
So fast. So
easy.
That's what I was gonna say.
So fast. So easy.
So local.
So Pet Supplies Plus.
So what now?
We're still with Mr. Burt and Ms. Baker, direct examination.
Thank you.
Mr. Burt, your witness.
Ms. Baker, would you take a look at, in your notes, page 24 of 379? Very bottom of the page. Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline, discussed that upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional. Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh.
Yeah, it should not be on the screen.
Let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the star mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twigs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
I'd move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through.
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twigs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, so Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it may be published to all screens.
Bates number on this?
Yeah, it's page 39.
No, but the actual Bates number, I'm having to find the file and provide this to you.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are 2 contributors, right?
Correct, yes.
You input sample 7A.
Correct, yes.
And when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis.
Correct, yes.
Right? And you put in sample 61.
Yes.
Right? That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay. And then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of 2 different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those 2 numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians.
And African Americans, yes.
African Americans. Another one for Caucasians.
Correct, yes.
SEH is Southeast Hispanics.
Correct.
And then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile, and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as opposed to going through all this, so we can move on to whatever else you would like to present.
Thank you. I will do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do it.
So is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to Plaintiff's Exhibit 31, which has also been admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right. So do you want that published on this all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, Plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay. And on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twiggs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the STAR mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample. I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout? So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 14-16.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7-9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received this, the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack, correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log. That was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half. You save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA. Or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay. And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, with not
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
No, be done with her. We talked earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by STRs but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the, on the public screen, just for the witness. And is this a chart that you reviewed, that I prepared to, and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride?
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt.
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations, relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations in the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that the Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right. I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state, Mr. McBride.
Oops. Good afternoon.
Good afternoon.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your Bachelor's in Biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner as well as the biologists were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform Language for Reporting and Testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. The directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading. And then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less, or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there is some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt? And how much time are you anticipating? Right.
You referred on cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right? Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory. And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up that needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
All right, thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right. Having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.